First case this morning is In Re Trust of Mastny. Mr. Domina, good morning.
Good morning, Your Honor. May it please the Court. I'm Dave Domina, and I'm here on behalf of the three daughters of Emil and Margaret Mastny. We ask that you review and reverse a decision of the County Court of Madison County, Nebraska, and we think that the standard of review which is applicable here, even though this is an appeal in a trust proceeding, is one that requires your de novo review because we believe the court below committed an error of law. And that error of law that we believe was committed, is that we believe the county court failed to understand the elements of proof of the doctrines of a sumsit or the theory of an account, and was reviewing the record for evidence of actual mutual assent to a debt when mutual assent was not an element of our claim and was not necessary to be proven. Emil and Margaret Mastny assiduously throughout their lives, or at least the last several years of their lives, made weekly accountings of their financial relationship with their only son, Ernie. Ernie farmed their land. The entries they made in their records looked like this entry, which in 1999 showed a debt in Emil Mastny's handwriting. Ernie owes me $94,500. Those sorts of entries continued until their health failed them in 2006 and 7 with entries like these. References in entry after entry to loan after loan to E.M., Ernie Mastny.
Are there checks corresponding to those entries?
Each of those entries, Your Honor, has a check corresponding with it, or, in most instances, or an invoice to a vendor where there was a check paid directly.
Are those checks drawn on a joint checking account held by Mr. and Mrs. Mastny before their deaths?
Yes, they were, Your Honor.
Is there any evidence that that account was ever transferred to either of the trusts?
The transfer occurred in the estate proceedings.
But it's one thing to say that Mr. Mastny owes his father something. It's another thing to say that Mr. Mastny owes a trust something. What evidence is there that any of the funds received by Ernie Mastny came from either of the trusts?
Well, there is no evidence that the trusts had assets before the parents died. There is only evidence that the parents farmed and the trusts were funded in their estate proceedings. And so what happened here is that the estates were administered, the assets were distributed to the trusts, there was a petition for the administration of the trusts. The estates were in Stanton County, the trusts in Madison County, and these proceedings then occur in Madison County.
At the creation?
Are the trust instruments themselves anywhere in the record?
I don't think so. And frankly, they would add nothing to your inquiry. The trust...
Well, it might help determine what the assets of the trust were.
They would add nothing to your inquiry. I understand your curiosity. But
my question was going to the same line, if I may, because I was trying to determine from the outset if the trusts were funded and if there was some evidence of it.
Well, the evidence that you have before you is that the assets came out of the estate proceeding and went to the trusts, and those assets constitute, or were and are, all of the assets owned by Emil and by Margaret Mastny, including their right to collect the debt from their son.
What shows that? What piece of evidence or pleading in the record establishes that?
The trust's accounting shows that the trust received all of the assets from the estates. That's where that accounting begins, Your Honor. And that's really all that is in the record to that effect. Because there was never a contest about this issue, the only contest that arose was the claim asserted here on cross appeal that this issue should have been litigated in the estate proceedings. The absence of evidence that I think that is important here and fatal to that position is that there is only the finding of the court below in this record and no evidence that there was any litigation of that issue in the estate proceedings at all. So the elements of collateral estoppel which are asserted here can't be tested by a record. Our record begins with a trustee saying, I, the trustee, have all of the assets of Emil and Margaret Mastny. I hereby account for them. They consist of these things.
That's where your story starts.
Well, I think that's where the trustee's story starts, Your Honor.
Okay.
It may not have been where Ernie's started, where the son's started, but the son didn't bring a record.
Do the checks themselves have any notations on it?
Yes, they do, Your Honor, and you'll see in the record that the checks refer to either of two things. Loan Ernie is the most common entry, or for account of Ernie if it's paid to a vendor. They are then logged into the books and records, and
The checks correspond then?
they do. They correspond by date, and in most instances they're also collated by check number.
So I'm curious, now you say the court didn't apply the correct law of assumption.
I think that's.
So
I think the.
Inform us, does a notation in one's personal affairs, a book, and then a check with a notation, does that equal a debt?
Well, we think it does.
And why?
And we think that's so because we believe the elements of a sumsit are these. Proof that money, element 1, was transferred from one person to another, element 2, under circumstances that make it unfair, and that is the language of the court, or inequitable, that amount of money not be repaid. There is no mutual assent element in a sumsit. There simply isn't one.
Don't you have to show that the parties regarded the continuing statement or ledger of the account to be an accurate representation of their respective indebtedness?
Yes, Your Honor, I think that's true. I think you have to prove up the amount of the debt, in other words.
So if Mr. Mastny testifies that he never saw these ledgers until after his parents' death, how would you meet that element? Because
the burden of proving that element is not proof of mutual assent. It's proof of the expectation of payment by the party who extended the funds. I think all we have to prove, Your Honor, is that the money moved. Mr. Mastny doesn't deny that it was received, so we have, to use even simpler language than a sumsit, money was had by the parents. It was received by the son. The parents prove an expectation for repayment, money had and received, or a sumsit. The son says, gee, we never talked about it, but I kind of thought we were settling up every year.
Is it an open account?
It's not a closed account, so I guess it is an open account. I personally think the theory of the law that fits most closely is a sumsit. As you know from the brief, I tried to catalog some of the historical linguistic descriptions of a sumsit. It seems like that's what it is, but I also included in the brief the theory of money had and received and the theory of account. I'm not sure how different they are. But what I do know is this: Emil and Margaret Mastny cataloged this debt. They had an expectation for its payment. That's how and why they cataloged it. There is no contradictory evidence. There is no proof of a gift. There's not even a claim of a gift except in the lawyer's papers after the fact. Ernie didn't say that in his deposition. What we know is that money moved from the parents to the son with an expectation for repayment under circumstances that cry out for some explanation that rebuts the inequity of non-payment. We ask that you reverse the county court and require that payment be made.
Let me go back to, I had a question about some of the checks which indicate that they're for farm expenses. How do those matters factor into this analysis?
Your Honor, father and son farmed together, filed separate tax returns, maintained separate accounts with vendors. When they sold produce, livestock, or crops, they divided those equally each year, and they kept their books, their records, and their operations separate. The county court thought there was a, quote, sort of partnership, close quote. There's been no claim of a partnership by Ernie. The books and records do not indicate that there was any common account between them, only land that one was a landlord on and another was a tenant on, may be a partnership in the owner of cattle, but a division of proceeds.
So are the farm expense checks included in the amount that you claim is owed?
In some instances they are, because they were cataloged in the continuing accounting by the parents of the loan amount. If they were not in these ledgers cataloged by the parents as a part of what aggregates to the loan amount, they're not in our claim.
We don't get many assumption cases. Is that an equitable doctrine?
I'm not sure, Your Honor. I think so, but I'm not sure. I think that if somebody had wanted a jury here, it would have been an interesting question. If the elements were not missed by the county court, your review, of course, is different than I have posited, but I think the elements were missed.
I had a law professor that badgered us for 3 days as to whether something was in equity or not.
Well, I've now had 12 minutes. Thank you very much, Your Honor.
Thank you.